This is the final decision of the contracting officer. You may appeal this decision to the Agency Board of Contract Appeals. If you decide to appeal, you must, within 90 days from the date you receive this decision, mail or otherwise furnish written notice to the Agency Board of Contract Appeals and provide a copy to the contracting officer from whose decision this appeal is taken. The notice shall indicate that an appeal is intended, reference this decision, and identify the contract by number. With regard to appeals to the Agency Board of Contract Appeals, you may solely, at your election, 1. Proceed under the Board's small claim procedure for claims of $50,000 or less, or 2. In the case of a small business concern, $150,000 or less, or 3. Use accelerated procedure for claims of $100,000 or less. Instead of appealing to the Agency Board of Contract Appeals, you may bring an action directly in the United States Court of Federal Claims within 12 months of the date you receive this decision. That was part of the contracting officer's decision that Charlie, our contractor, just read. The decision was issued by Jason, the contracting officer. Jason and Charlie have been in a dispute after Charlie's company incurred costs while performing their government contract to install a running track next to the gym. During performance of the contract, Charlie's crew found a large rock that needed to be removed, so they removed it so they could finish the job. Charlie's company spent $100,641 removing it. Surprisingly, Charlie and Jason have not been able to resolve the dispute at the contracting officer's level through a request of equitable adjustment, through a claim, or through using alternate dispute resolution techniques. Most notably, Jason rejected a large portion of Charlie's claim, saying Charlie's expenses were unnecessary and excessive. Charlie does not agree with the decision to disapprove the majority of his claim, and he is considering appealing the contracting officer's decision to the higher courts. If Charlie does decide to appeal the decision, it will be necessary for both Jason and Charlie to know what to expect. Charlie learns that if the contracting officer's decision rejects either part of or his entire claim, he may appeal to the higher court. If Charlie appeals the contracting officer's decision, he must do so within certain time limitations. Appeals may be submitted to either the Armed Services Board of Contract Appeals or to the United States Court of Federal Claims. In order to be accepted at the Armed Services Board of Contract Appeals, or ASBCA, the appeal must be received by the ASBCA within 90 days after receipt of the contracting officer's decision. In order to be accepted at the United States Court of Federal Claims, or CFC, appeals must be received within 12 months after receipt of the contracting officer's decision. If Charlie doesn't submit his appeal within the established time limitations, the contracting officer's decision becomes final. And final means that it becomes binding on both parties and is not subject to review by any government agency, tribunal, or forum. If an appeal to the ASBCA has been submitted in a timely manner, it may be reviewed. The ASBCA is a neutral, independent forum whose primary function is to hear and decide post-award contract disputes between government contractors and the government. A panel of 3 judges makes most decisions. The ASBCA functions in a collegial fashion. Members of the ASBCA make contract appeals decisions to the best of their ability based upon the records of each appeal. If you've ever heard an instructor or your supervisor say, "Document, document, document," this is one of the reasons. All ASBCA decisions are based on applicable laws, regulations, contract terms and conditions, and most importantly, the documentation and evidence supporting each of the parties' positions. So, let's say Charlie decides to appeal the contracting officer's decision. He will notify the ASBCA and the government of his decision by submitting a Notice of Appeal. The Notice of Appeal should contain 4 important pieces of information. 1. The contract number. 2. The department and/or agency involved in the dispute. 3. The decision, or contracting officer's decision, which is being appealed, and 4. The amount in dispute, if known. Charlie will also submit an original and 2 copies of documents called the pleadings or the complaint to the ASBCA. The complaint states in simple, concise, and direct statements the basis of the appeal, the contract provision in question, and the dollar amount claimed if it's known. The complaint may be filed at the same time as the notice of appeal, or it may be filed separately. The ASBCA will forward a copy of the complaint to the government if Charlie doesn't. Jason will then respond to Charlie's complaint by submitting an original and 2 copies of documents to the ASBCA. Jason's documents will answer or provide responses to the complaints filed by Charlie. Jason's response will state in simple, concise terms direct statements about the government's defenses to each claim asserted by the appellant, Charlie. Upon receipt of Jason's response, the board will provide a copy to the appellant, Charlie. Jason is wondering when the real fun begins. Don't worry, Jason. You're about to have lots of fun working with the preparation, content, organization, forwarding, and status of appeal file, better known as the Rule 4 file. It's called the Rule 4 file because it's Rule 4 of the ASBCA's rules. It's quite possible for Jason to prepare the contents of his Rule 4 file at the same time he responds to the complaint that Charlie filed. Jason can save significant time and effort by organizing and preparing these files at the same time. Jason goes to DFARS Appendix A to read about the Rule 4 file requirements. Within 30 days of the receipt of an appeal or notice that an appeal has been filed, Jason assembles and transmits the Rule 4 file to the ASBCA. The Rule 4 file consists of all documents pertinent to the appeal, including 1. Decision from which the appeal is taken. 2. The contract, including pertinent specifications, amendments, plans, and drawings. 3. All correspondence between the parties relevant to the appeal, including the letters of claim in response to which a decision was issued. 4. Transcripts of any testimony taken during the course of proceedings. Also, affidavits or statements of any witnesses on the matter in dispute made prior to the filing of the notice of appeal with the board. 5. Any additional information considered relevant to the appeal. Jason works closely with his legal office to get the file in the best position to win the decision. After the contents of his Rule 4 file have been gathered, prepared, and organized, Jason sends a copy of the file to each the ASBCA and to the appellant, Charlie. Then, within 30 days after receipt of Jason's Rule 4 file, it's the appellant's responsibility to send the board and the government any documents which they feel is relevant to the appeal in response to the contents of the Rule 4 file. During all of this correspondence and document exchanging, Jason and legal do a great job at working together to 1. Ensure files are complete and accurate, and 2. Free from accidental disclosures of privileged internal documentation. This is a lot of document exchanging. And these are the first 5 or 6 rules of the ASBCA's appeal process. But the good news is that progress has been made. These steps establish an important baseline of information exchange of and relating to building the case. Charlie is not excited to hear there are potentially 30 more rules or steps for Jason, Charlie, legal, the ASBCA, and others to go through in order to process this appeal. The next 30 rules include Rule 7, Amendments of pleadings or records. Rule 8, Hearing election. Rule 9, Pre-hearing briefs. Rule 10, Pre-hearing or resubmission conference. Rule 11, Submission without hearing. Rule 12, Optional small claims and accelerated procedures. Rule 13, Settling the record. Rule 14, Discovery, depositions. Rule 15, Interrogatories to parties, admission of facts, and production and inspection of documents. Rule 16, Service of papers other than subpoenas. Rule 17, Hearings where and when held. Rule 18, Notice of hearings. Rule 19, Unexcused absence of a party. Rule 20, Hearings, nature, examination of witnesses. Rule 21, Subpoenas. Rule 22, Copies of papers. Rule 23, Post-hearing briefs. Rule 24, Transcript of proceedings. Rule 25, Withdrawal of exhibits. Rule 26. Representation of the appellant. Rule 27. The government. Rule 28. Decisions. Rule 29. Motion for reconsideration. Rule 30. Suspensions, dismissal without prejudice. Rule 31. Dismissal or default for failure to prosecute or defend. Rule 32. Remand from court. Rule 33. Time, computation, and extensions. Rule 34. Ex parte communications. Rule 35. Sanctions. Rule 36. Effective date. Jason received some new correspondence in accordance with Rule 7. The ASBCA has asked each party to make more definite statements about the complaints and answers to the complaints. Jason begins to think this is a bad dream. Then bam! It was a dream. Wow, Jason is relieved. As Jason lays back down before slipping back into his nighttime slumber, he thinks how valuable that dream was. He remembers how important it is to try to resolve disputes at the contracting officer's level. And he remembers the Contract Disputes Act of 1978 and how it establishes the procedures and guidelines for resolving disputes and claims. Just for a second, he contemplates the ways that requests for equitable adjustments and claims are alike. And in another quick second, he remembers the 14 or so steps to process claims and REAs. As he drifts back to sleep, he remembers that utilizing alternate dispute resolution techniques must be mutually agreeable to both parties and that ADR is much less expensive and quicker than going through the appeals process. And speaking of the appeals process, the last thought in Jason's brain is about how valuable it is to know the initial steps of the appeals process, whether the appeal is submitted to the ASBCA or the Court of Federal Claims. Rest easy, Jason, because tomorrow you need to tackle that unauthorized commitment.